So two lawyers, Martin and Abdullahi, disagreeing, completely, opposite directions. Let's bring in the professor and hear from him about where he stands. Even though it's controversial to suggest that this is non-conviction based, whatever it is, because this is not. Professor Abotsi.
Good morning, Simpson. The reason the two lawyers disagree is precisely because we're in the realm of the exercise of prosecutorial discretion. When discretionary power is invested in someone, that person has a right to exercise judgment. And when people exercise judgment, it is not unusual to have third parties affected or third party commentators disagree on the basis for the exercise of that discretion. So the fundamental premise, the politics will take its course, but the fundamental premise is for us to just reduce things to the barest minimum, and that is in the exercise of prosecutorial discretion, like all discretionary authority under the Constitution. Two key provisions of the Constitution regulates the exercise of discretionary authority. But these two provisions agree on one fact, that the exercise of discretion is not unregulated, it is not unrestricted, and it shouldn't be capricious. And so when a person exercises discretionary authority and we challenge that, we have to benchmark it against the provisions of Articles 23 and 296. And we would have to challenge it by showing that it is unreasonable. If we are not able to establish that, then we cannot impeach the exercise of the discretionary authority. The point I'll make at this stage is for us to remember that when an attorney general decides to exercise the power of nolle prosequi, which forms, among others, like withdrawal, part of the exercise of that prosecutorial discretion, there is always the liberty to recharge the person. There's always the liberty to come back on that. And so it's not as if this is foreclosed for the rest of all time. It is possible that in the future, the attorney general, this same attorney general, or some other attorney general, might decide to reopen the case in respect to the same facts, and the processes might go underway. So the point I'm just trying to stress is that the fact that the attorney general has come to a conclusion that the circumstances warrant a discontinuance of this case, that there are justifications that back a decision not to prosecute the formerly accused person involved. One can only comment on these, but the authority is vested in the Attorney General. And as I indicated, if we want to impeach it in terms of our own commentary, we'll have to establish that it is unreasonable. So the key question is whether the exercise of the authority is unreasonable.
Where do you stand? That we have a matter in which the state is said to have lost in excess of 5.7 billion in respect of this particular case. Then the Attorney General makes a decision that because we have recovered 60% of that money, he's comfortable not pursuing this matter any further. So the 60% will be about 3.4 billion. And then the question is, who is taking up the 2.28 billion that will be left?
So let me state one pro and one con, and then I'll indicate what my position is or what I think my position is in this matter. So the pro is this. First of all, when a court or an attorney general is making decisions on the preference of charges or the determination of guilt on a person, one of the key factors that are considered is the issue of scapegoating, whether or not the offense, the person is a repeated offender, and in this context, whether or not anybody has even been punished in respect of a similar behavior in the past. It would seem that there is a sense of scapegoating here, i.e., even if this had happened in the past, perhaps there hasn't been a prosecution, or perhaps there hasn't been, the state hasn't chased after this to ensure that there's a refund. So the accused person involved may perhaps be facing a scapegoating scenario, being scapegoated for the first time to demonstrate the state's resolve not to tolerate this moving into the future. And for scapegoat purposes, one is confronted with both punishing harshly to make a statement that this shouldn't happen again, but also one is confronted with the reality that this person is truly the first person being punished. Not only is there no template, but this person, unfortunately, is being used as a scapegoat. So should not unnecessarily be unduly punished. These considerations can pull a decision maker in different directions, and the Attorney General will have to make a consideration of whether or not the person should not be unduly punished, given the fact that he's the first person to face similar charges moving forward into the future. So I suspect that the AG might have confronted this, the fact that we haven't had anybody facing a similar punishment in the past, and so we shouldn't unnecessarily, unjustifiably punish him, or rather subject him to a rather high standard when others might have done this in the past and nothing happened. So the scapegoat effect might have weighed heavily on his mind. So that's one proof.
If we're talking about precedent, then the point will be that in the bank collapse, matters, the state has incurred in excess of 30 billion Ghana cedis in the cleanup exercise, as the previous government, sought to do. And in those pictures, you will see that our research team put side by side Dr. Dufour and Ato Essien. Ato Essien, the Attorney General the state determined that he had a liability of 90 million to pay. He pleaded and was able to pay almost about 40 million, but he's in jail.
Well, that's correct. Again, first of all, let's be clear. I do not know the exact considerations that went into the Attorney General's decision-making. I'm only second-guessing him, and I'm just using general principles to make a point. And the point I'm just trying to stress is a person making such a decision, especially in respect of someone who might be facing this for the first time or was among a group of people who faced a similar thing at the same time, will consider the scapegoating effect. But the point you've made is equally correct, i.e. the fact that we would have to have a comparator in mind. And the comparator or the comparative framework here, the person involved is probably in jail. If I did hear your figures right, it may seem that Dr. Dufour is paying higher, or rather is paying more than Mr. Ato Essien currently has paid. And
every individual bank and what their liability was.
Correct.
Out of the total of 420 financial institutions that were affected.
Correct. But again, I'm saying again, we are second guessing. But I'm just saying that if one looks at the figures and it seems that the payment being made by Dr. Dufour is proportionately smaller than that of Mr. Ato Essien, who's in jail, then of course there are questions to be raised, and then of course there are concerns in this case in terms of what exactly the metrics and mechanics in arriving at this determination is vis-a-vis another person who's in jail. The truth of the matter is, in many of these decisions, no two cases are alike. One consideration, for example, that is made by a court in the determination of sentencing, the consideration of extenuating circumstances or the aggravating circumstances. Decision makers at the level of preferences of charges also make the same considerations, whether or not there are extenuating circumstances. And those extenuating circumstances might, for example, include a consideration of whether the person has shown adequate remorse, whether the person has cooperated or collaborated in the recovery process, whether the person has even, quote unquote, snitched on other persons and therefore helped the state in the recovery of money from other third parties. The point I'm making is there's so much one doesn't know at this stage, and perhaps we might just want to wait and hear from him on Monday. But there's so much one doesn't know at this stage, and there will be a lot of second guessing and a lot of what if, or if X is that, then Y has to be this way. My point
as a taxpayer, we were saddled with a financial sector recovery levy, which has so far collected some 2.13 billion Ghana cedis. As in, so that we who didn't do anything wrong, me, the taxpayer who did absolutely nothing wrong in the bank collapse, which the state spent in excess of 30 billion, I am being asked to pay for the state's decision to spend that money for the recovery or the revival of the industry. As a taxpayer, how do you feel that this is how the problem is being resolved by the people that were accused, particularly in one bank, of a liability of 5.7 billion?
I'm a very unhappy taxpayer in that context, Samson. And there are there are examples around the world. The too big to fail American scenario. There are examples of how there were consequences and people had to pay certain prices for certain conducts. For example, one of the things that makes me very unhappy is the fact that the people who were at the helm of the regulatory regime in the country at the time, why are we not having answers? These were the people who were supposed to ensure that related party transactions were not only kept to a barest minimum, but in some circumstances just did not happen at all. If you hear some of the stories, it would seem that there were clear cases of fraud. And it does seem that people who were actually paid at the time to ensure that these things did not happen, those persons, I still haven't heard any charges being preferred against anybody, and I'll be happy to be corrected. So
you're right. You're right. Nobody is standing trial as a regulator or involved in the regulatory exercise over the bank collapse.
In some regimes, you will actually hear cases of regulatory complicity because these shouldn't happen. Now, apart from the regulatory issue.
And Prof. Abotsi, just a second. In fact, a former, deputy governor, who is now the governor of the Bank of Ghana, was to answer for some of these. But as we know, he was also let off on the basis that by an examination of the processes or the docket, there has been an advice that he was not liable or something. So he is now back as the governor of the Bank of Ghana.
Well, as I indicated, look, at this stage, one has to just look at things holistically. From the Attorney General's perspective, the difficulty we have at this stage, and it is a testament of some credit to the current Attorney General that he actually speaks to reasons why he makes decisions the way he does. The truth of the matter is the law allows the Attorney General to make decisions without explanations. And so we would typically not know what informs his decision, in this case, to accept the payment by Dr. Dufour and, bring matters to a close. We will not know the reasons for that. But as I indicated, the justification or one justification that one might proffer is the extenuating circumstance of the cooperation of the parties involved. If a party who is being charged or who has been charged provides sufficient evidence justifying his conduct, if that party cooperates or shows remorse, if that party repents, and if that party ensures that the state ultimately gains something from, or rather the state recovers something from whatever has been looted, so to speak, a decision might be taken, which I might find plausible. This one, on the face of it, the justification for it is the fact that the state has made some money, i.e., the state is not losing entirely in respect to the party involved. The questions about what happens to the balance of the amount involved is one that is a plausible question to be asked by the state. But in the absence of the explanation, we can only second guess. And
the state suggests in an official communication that you are doing a trial, you are expending state resources and money, and it doesn't make sense to continue spending in that regard. I doubt by your experience and in your training of lawyers and even people within the justice system and the Attorney General, you will make this, recommendation that the balance of 2-point-something billion, it's okay to let it slide rather than spending state resources to prosecute people over that.
If the state can recover it, I will never make that recommendation. Look, in taxation, there's a principle that you don't use good money to chase after bad money.
That's right.
You don't use resources to look for tax money that you may potentially not get. In some ways, that one might say that may even apply in this case, i.e., if the state deploys resources to get this money back, will the state make it back? Perhaps not. But the counter argument for others would be the state should not necessarily choose to go after the money. And if the state can't get the money back, then the collateral punishment or consequences in criminal justice should apply. So that's the point I'm making, that ultimately, all these considerations are legitimate, but they are speculative. In the absence of the knowledge of the basis, the mechanics, the metrics that went into consideration of why the percentage of amount of money paid is adequate and sufficient and a good basis to foreclose the matter, we might just have adequate information that justifies that. But until then, we can only speculate.
All right. I'm bringing my other guests in to look at the other aspects of financial sense in all of this. But I'd like to end with you on this question. Of course, there were standing trial on charges of willfully causing financial loss to the state, money laundering, and dishonest appropriation of public funds. The Attorney General, in its letter, which it came to the public, said that the decision does not, and I'm quoting them, does not imply an absence of wrongdoing nor a vindication of any conduct. They say this was only practical step aimed at avoiding further legal and administrative cost. So I heard you suggest that because this was not a plea bargain, so to speak, which would have terminated the trial in a manner that does not allow them to be brought back in future, you are saying that this may be resurrected in future? Would you have it resurrected in future?
I do think that it is plausible this matter may be brought back in future, especially if you have a situation in which a new evidence is discovered. If the Attorney General entered nulli pro sequor as nulli pro sequor, then potentially you can bring it back in future. You can't bring it back in future. But if the Attorney General just withdrew it, or you said earlier that because of an entry of nulli pro sequor, this matter could be revisited. That's why I asked you the question. For nulli pro sequor, no. If it was, again, I don't know I have to confess on this. I haven't followed exactly there's withdrawal and there's nulli pro sequor. You can't bring charges in respect of one, but you can bring charges in respect of another for the future. But even for nulli pro sequor, once you can discover a material fact, which wasn't part of the circumstances that led to the withdrawal, a matter withdrawn under nulli pro sequor might just be revisited on new charges. The point is, once you have an additional charge or once you have a tweaking of a charge, the matter is a new charge altogether. So this is not something which is entirely closed. It doesn't stand in the same double jeopardy context as an atrofo convict, where a person might have been convicted and that's it. You can bring back the matter again. In this circumstance, once you can find something which is materially slightly different from the current charge, even for the future, there could be a re-prosecution of the person involved.
Okay, thank you. Prof, stay there for us and let me get my other guest